you're selected as a mediator to work on a dispute involving one of my clients, I want you to ask me the kinds of questions that I'm going to review in this video. And I want you to ask my opponents and the other parties involved in the mediation the same sort of questions as well. Because anybody who's gotten this far and watched some of the other guided choice videos that I've recorded knows that I tend to harp on the idea that there needs to be a thoughtful process created by the neutral, by the guided choice mediator, with the input of the disputing parties, after confidential discussions with them, in order to create a suggested process that will require the buy-in of the parties. No one's forcing anything on anyone, about how the mediation can be conducted in a constructive way, so that areas of potential impasse and disagreement that the parties are likely to anticipate, are spotted in advance, and that there be a process put in place to overcome them. And so, these are not my ideas. I was very lucky to work for almost 14 years very closely with my former law partner at Schiffard and Paul Lurie. And what I'm going to cover today are ideas that he's helped me understand, and certainly these are the ideas of some of his guided choice mediation collaborators as well. These are not in any particular order. It's not an exclusive sample, but to make this less abstract, if you're a neutral, one of my cases, I want you to ask me things like, what's the history of the business relationship between the disputing parties? Is this a one-off deal, or are they working in the same market and likely to do business with each other in the future? What is the history of this particular dispute? Is this something, that came up quickly, or has it been festering? Is this something that led an employee of one company potentially to get fired? Or is this, just your run-of-the-mill change order dispute that, you see in design and construction cases? Who are the people in the client organization who determined that disputing party's current position? What people will be involved in the future in determining their settlement position, and specifically whether it makes sense for them to try to negotiate, or whether this is one of those cases where they're best off to fight on in litigation or in arbitration. Who's going to participate in the negotiations? Are those the right parties? Is there a concern that any particular disputing party involved in the case will view your recommendation to mediate as a sign of weakness? Is there a chance that there are political or cultural or social reasons why they might think a win involves them settling on the basis of a proposal that they set out, instead of on the basis of a proposal that you as the neutral sets out? What are the applicable, contractual or, court rule requirements that could affect the parties' settlement choices if they are either, in litigation or standing on the precipice of it? Is it possible that there are complicating factors like that need to be taken into account, like conflicting rules of multiple venues, possibly around which parties can be joined? Particularly if there are parallel arbitrations and litigations happening. In the event that those binding dispute resolution processes have been initiated, whether it's litigation or arbitration, what's the likely date that the matter is going to reach some binding decision of the arbitrator or the judge or the jury? What's the time to trial? Where are we in discovery? How much of an opportunity is there to influence the process, and how much of that process is already, taken out of life of its own? I'd like for neutral to ask me things like, what information, Jeremy, does your client need to evaluate its position and make a strategic decision about whether it makes sense to pursue settlement now, or whether they want to proceed ahead in litigation or arbitration? Jeremy, how's your client going to access that information? Do you have it on your own? Can you gather it yourself? Does the information need to be provided by third parties? And if so, are they cooperative or non-cooperative? Is this the sort of thing that could potentially be handed over in mediation by parties who are required to mediate, or is it necessary for there to be some sort of subpoena power involved for that critical information to be obtained, because there's certainly nothing inconsistent with guided choice dispute resolution playing out in parallel to some form of binding dispute resolution, where a party might be able to go into court and to obtain subpoena power to get the information that they need in order to settle. What resources, will a lawyer, use to gain information necessary, for adjudication or for settlement? For example, law firm lawyers and staff, experts, data analysts, is this something that is, again, going to be done on a collaborative or an adversarial discovery basis? I don't have any problem being asked, what are the lawyer's fee arrangements? Is it contingent? Is it hourly? Are people facing budget constraints? Are they being prepared? Are the lawyers bearing any of the risk of the dispute with caps on their fees, things of that nature? I certainly want a guided choice dispute resolution neutral to ask after, who are the key stakeholder entities in the dispute, including insurers or vendors or subcontractors or government agencies, parent companies, joint venture partners, who has an interest in this dispute? Which of those parties may have had an influence on the disputing parties in reaching whatever position they've taken that has led them to the impasse that has caused them to hire a mediator? How did the opposing party reach the position that it took that has led to the impasse? What are going to be the consequences for the parties if settlement is delayed, right? This could certainly include financial consequences, but there are other consequences. An ongoing design or construction project may suffer tremendous adverse consequences if it's delayed, for example, beyond just financial consequences. So what are the consequences if the parties are not able to get together and to settle on reasonable terms, or at least have a thoughtful discussion around whether it's in their strategic interest to settle or to fight on? What's the likelihood that the dispute will escalate if it's not settled in short order? And, what would be the reasons for that escalation? Are there any uncertainties or fears that might be associated with the settlement? And this might be the fear that, if you settle with one party and you give them a release, that you're going to find out later that there is some unresolved issue that is not possible to take and lay at their feet anymore. That's just one of many examples of uncertainties and fears that might be associated with the parties either agreeing to settle now or not. What are the group dynamics present? Are there multiple levels of approvals needed for changes in settlement position, right? I mean, this could certainly require insurance claims representatives at higher levels that can, beyond a certain threshold, exceed the settlement authority of a particular officer of a corporation. Beyond a certain threshold, it might require joint venture partners to get involved. So, who are these people, and are there group dynamics present? Is it the case that maybe one of the disputing parties would rather have a bad outcome in this dispute than look bad to their joint venture partner, who might be able to work with them on a bunch of additional lucrative deals, as long as they don't lose faith in the disputing party, right? So is there maybe a perverse incentive structure for a party to care less about resolving this dispute, than they may otherwise care? I think it's fair for a neutral to ask, who's likely to resist the involvement of a mediator, and what would be the reason for that resistance? I think that it's fair for a neutral to ask lawyers, what has your experience been using a mediator? What has frustrated you? What have you seen work and not work? Same question to those lawyers' clients. Are we dealing with people like me who strongly believe in the virtue of a good mediation where the table is properly set? Or are we dealing with people who are dismissive and intending only to show up because they have a mediation clause in their contract? I think it's fair for the mediator to probe the parties' good or bad experiences in the past, using courts or arbitrators to resolve disputes. I think it's fair game for a mediator to try to probe parties to get at the question of whether they believe that that the opposing parties are amenable to settling now. And if the answer is no, then why? And if they believe that there is an opportunity for settlement now, then it's important for the mediator to understand, why that's the case. I think it's fair for a mediator to try to probe a party's thoughts on what sort of an outcome would be in their best interests, as a business, as business people, overall. And so this is just the beginning. I mean, we have covered in no particular order a non-exclusive sample of the kind of questions that I think any mediator, but certainly one who is using the practices and the principles of guided choice dispute resolution should be asking a wide variety of parties who are involved in the dispute. And because mediators that understand the principles of guided choice, which, again, are not anything that Paul Laurie or anyone in particular invented. It's just a collection of the best practices and procedures of, in my view, the best mediators. If you have a mediator that affiliates with guided choice or not, that is steeped in these best practices, it's the sort of thing that I would expect them to be asking at the outset of their involvement. And to be very frank, I really don't want to hire a mediator that is not going to ask me questions like these and many other questions like these, that the mediator will arrive at being potentially important based upon their confidential diagnoses with all sides. Because it's essential to me that the neutral ask those questions of the other side so that they're able to call a play on what is the process that is most likely to lead to that early cost-efficient dispute resolution that our design and construction clients so badly hope to achieve, so they can get on to what they do best, which is design and construct wonderful spaces for the enjoyment of us all and the betterment of society.